Right, well, the judgment has been reserved in the North Gauteng High Court, where the DA is fighting to have corruption charges reinstated against President Jacob Zuma. Those charges were dropped in 2009 for a wrap of today's court proceedings. Our reporter eNCA's Karyn Maughan joins me in studio. Karyn, a pleasure to have you here with me. So, all right, today was the last day of the DA's application to have the decision to withdraw criminal charges against the president set aside. What were the main points raised by the opposition in terms of strengthening their argument then?
Well, they're essentially saying that there's no evidence whatsoever that the interventions or interference of Leonard McCarthy and Bulelani Ngcuka in any way affected the substance of the case against President Jacob Zuma. And they're saying effectively that it's not just a remedy to say because there was this intervention in the timing at which he was indicted, which basically what their case is that Leonard McCarthy and Bulelani Ngcuka were very pro Thabo Mbeki, and they wanted to delay the timing of the indictment so that President Zuma would not be seen as a victim of Mbeki, and it would in fact improve Mbeki's chances. That of course did not succeed, and they're saying that, you know, there was this interference with the timing, if there was, but ultimately that shouldn't taint the whole case. And they've also questioned why, if it was Leonard McCarthy or Bulelani Ngcuka who did these things, why no action was taken against them and the case was just summarily dropped. And they're saying that's irrational. And they're also criticizing Mokotedi Mshe. They're saying that, you know, they're not suggesting in any way that at this point that he had malafide motives or he was coming from a place, a bad place in terms of his decision. They're not trying to suggest that it was a corrupt or problematic decision, but they are saying he was impulsive and emotional, and he should have actually asked a judge. Should have taken the case to court and said, this is the situation. What does the court believe we can do? Should we actually go ahead with this prosecution? Which we know was the position adopted by the prosecutors in this case in the first place.
Well, Karyn, I suppose it's becoming quite clear, and you'd help us out here, perhaps to the DA as well, that, you know, the court can't make the NPA prosecute. And maybe you can take us through the details of why, and you know, why that's the case.
Basically what happened was that there was this challenge, Freedom Under Law brought a challenge to the NPA's decision not to prosecute crime intelligence boss Richard Mdluli for corruption and, in a separate case, murder. The Pretoria High Court found that that decision was indeed irrational and ordered the NPA to prosecute him on the charges. It was then kicked up to the appeal court, and the appeal court said, yes, we absolutely believe that this is an irrational decision on the part of the NPA, but we do not believe that a court can order the NPA to prosecute an individual, because that goes over, that violates the principle of separation of powers. We have to believe that the police commissioner and the head of the NPA is independent and has enough integrity to make their own decision-making process, and therefore we will not intervene. So while you could have a situation where this court finds the decision not to prosecute was irrational, ultimately it will be up to NDPP, Sean Abrams, to make a determination on whether the NPA will actually pursue charges against Jacob Zuma. The DA says that is enough for it. It wants, in that situation, if there is such an order, it wants a full explanation from the NPA as to why it doesn't prosecute Zuma.
All right, so where are we now? We understand, of course, the bench has a reserved judgment. So what can we expect now going forward?
Well, basically, Judge Aubrey Dwaba told the court that he was aware that this is a huge public interest case and that this judgment will be dealt with in due course. We could probably expect a ruling in between 1 or 2 months. And remember, of course, that this is running parallel to that very crucial and Nkandla court case in the Constitutional Court, which the President's lawyers have expressed a great deal of reservation about, an apprehension that it may be used as a possible ground for seeking his impeachment.
All right, Karyn, thank you very much for bringing us up to speed with that. We appreciate it. That's eNCA reporter Karyn Maughan.